Welcome back to the Cordell and Cordell live webinar that we're broadcasting worldwide. I'm Scott Trout, CEO and managing partner of Cordell and Cordell, and we're glad to bring this series back to you where we present some of the Cordell and Cordell attorneys from around the country to bring you some of the unique tips and ideas and comments on all issues affecting men before, during, and after divorce, especially during this period of COVID-19 and this pandemic that really seems to affect all aspects that relate to guys in divorce, whether they're post-divorce or pre-divorce. So we want to bring you some of the latest information with regards to that. We will have, again, 6 panelists today, so we'll talk to 4 of them in the beginning. We'll take a small break, bring on our final 2 panelists for the afternoon. Something new for today, and I encourage you, is we're going to take live chat questions. So submit your questions. We'll get to those at the end of our period today, but do that as much as you can, and we'll try to get those and get our panelists to answer those questions. If you can't submit live chat or you don't want to, continue to submit your email questions at coronavirus.divorce@cordelllaw.com. I answer those questions dedicated at a podcast during every week. I do a daily podcast. I encourage you to check us out on Men's Divorce or Cordell Cordell YouTube channel, and we'll answer some of those particular issues, but we devote an entire podcast to answering your questions. But I encourage you today, submit those chat questions right now. We'll get to those after the break. We'll have our panelists, and I'll throw those out to them and have them get you some information. As always, every week, I make sure to let you know that we cannot give you legal advice and do not take today as legal advice. Each of your particular circumstances, your facts, your cases are unique, and those things and the things we talk about certainly would change once we have that consultation. As we mentioned consultation, as you know, each week I mentioned to you, we are open. We're available for virtual and telephonic conversations and consultations as well as in person, but health is first, and that is a priority to make sure that if you feel uncomfortable, we're certainly available to you via Zoom, WebEx, whatever you're comfortable with. We can also do that via phone. Check us out at cordellcordell.com, or you can contact us at 866-DADS-LAW. Again, check out our podcast. We'll continue this webinar series next week. We're also going to be broadcasting live to the UK next week. So check us out for more information about how to join so we can reach guys and answer the questions for those guys in the UK, as we have an office in London as well. So let's turn to meeting our panelists today so that we can get right to it. First up, we have a repeat panelist coming from Maryland, Kumara Chandran. Welcome, Kumara.
Hi, Scott. Thanks for having me again. For those of you who didn't see me last week, my name is Kumara Chandran. I'm a litigation attorney outside of the Baltimore office of Cordell and Cordell. I've been practicing for 7 years, and I've been with the firm for 2.
Thanks, Kumara. Joining us from Ohio is Melinda Kaufman. Melinda, welcome.
Hi, Scott. Thanks for having me today. As Scott said, I am from the Ohio office. I'm also licensed in Florida. I've been practicing for 10 years and have been with Cordell for just over 6.
Thanks, Melinda. And joining us again from Florida as we try to bring you attorneys from Cordell and Cordell from around the country to give you the latest information is Allison Morris. Welcome, Allison.
Hi, Scott. Thank you for having me again. As Scott said, I'm in the Miami office. I'm a litigation manager. I've practiced all over the state of Florida. I've been with the firm for almost 10 years. I've been recognized the past few years from Florida Rising Stars in family law practice by super lawyers, and I'm happy to be here.
Thanks, Allison. And again, trying to expand our reach and give you more information throughout the United States from Utah, Doug Anderson.
Hi, Scott. It's good to be here. Thank you. I'm the regional managing attorney for Cordell out of the Utah office. I've been with Cordell for 8 years. And on top of that, I'm also a divorced father of 4 children and currently navigating the custody issues that deal with COVID. So glad to be here.
Thanks, Doug. I think that's an important point for guys that are watching. And, you know, this live broadcast is finding someone who knows where they are. Kind of the same situation, understanding the things they're going through, kind of exemplifying a partner men can count on here at Cordell and Cordell. So one of the things before we get into the heart of our webinar today is to try something new, which is talk about the latest news. So if you look around the web and you search for articles on divorce, one of the things that kind of caught the national spotlight over the last 5 days, and you may have seen it, and I wanted to talk a little bit about that with our panelists, is an ER doc in Florida lost custody of her child recently, simply because what appeared to be is that she's a ER physician. Premised upon the fact that obviously her actions and being in the ER makes her at higher risk to contracting COVID-19, and therefore putting her daughter perhaps at a higher percentage chance of getting sick. Father filed a motion, judge ruled, gave dad custody temporarily during this pandemic. Now, I think it was yesterday or today, the Court of Appeals has stayed that order, but I thought it was important to talk about this article simply because if you read it, and you'll find it on the web, it really exemplifies what we at Cordell Cordell for the last 30 years have been battling, and that is this unconditional or unintentional stereotype gender, where if you read the article, they really make it a point to say that she's a mom. And how dare you take this child from mom and make her have a choice between being a mother and being an ER physician. Totally understand it, not to denigrate the first responders because we know that that is an important role. But the point I think I'm making here, and I want our panelist opinion, is what I refer to as equal opportunity outrage. I've scoured the internet, I've looked for articles about guys. There isn't one single article out there about guys in the news who have been denied custody. Not one, simply even unattached to a legitimate reason. And so that's important. I think what happens to make national headlines is simply this. And so Melinda, I guess the question for you up in Ohio is, in this instance in Florida, mom or dad went in a temporary motion and made some arguments that it was an emergency relief. Is that available in Ohio right now?
It is. Our courts are still accepting motions for emergency actions. Some of the hearings have been either held via phone conference or a video conference. The court is not allowing the public, for most of our courts, the public into the courthouse. So I've even had some occasions where the court is just requesting that the parties submit written affidavits within a 24-hour period before ruling on it. So they are available for any type of emergency motion that may need to be filed.
I think it's an important point that you make because, you know, words matter, and all we read today, and I was looking through the internet again, about closed. They continue to use the word "we are closed" or "courts are closed," "cities are closed." And guys out there watching right now, and the guys that listen to my daily podcast think, I can't do anything because everything's closed. So, you know, as you indicate, Ohio's open, and I guess the question really begs is, what is the standard on a temporary motion out there? What do guys really need to prove in order to get some relief in Ohio?
So really in Ohio, and again, each court operates a little differently, but for the most part, you have to have some kind of imminent harm to the child for that emergency action to be granted. The court does not like to grant emergency motions unless there is some harm or imminent harm to the child.
So Allison, down in Florida, obviously this came from your state. So guys really want to know kind of what you're hearing about this case. And more importantly, you know, if I read the article uses the words, you know, cruel, and really, you know, adds these words to give emphasis. Cruel that mom had to make a decision. Is gender an issue? Is it kind of this unintentional bias out there in Florida? And then you can let the guys know what you're hearing about this case now.
Absolutely. I think that's a great question, Scott. In reality, I think it's an important point to note that a lot of this attention about the gender issues is coming from the media. It's not coming from the actual court order. I practice in Miami. We have a number of cases in front of this particular judge, as well as the other judges in Miami. And the order, the decisions, they had nothing to do with the fact that this was the mother. That's really more coming from the media. In fact, even though the mother's arguments in this particular case were that she felt she was being discriminated against as a divorced parent, that she was forced to choose between being a first responder and a parent. It wasn't against a mother or anything. So I think it's an important distinction to note. And really, realistically, I don't think that the law is really pushing one way or the other. It's just that I think a lot of times the perception is that fathers think that they don't have as much rights or they don't have an ability to do anything. And it's important for them to fight back. It's important for them to file motions and come to us and talk to us about what their rights are so we can make sure that those are being enforced properly.
I think that's an outstanding point when you talk about feeling defeated, you know, adding a layer of, you know, the media pounding away that guys, perhaps they're not as important as moms, and the media, you know, making this a huge event. And the question really becomes is they feel like they can't do anything. So, as we asked Melinda, but let's talk to you really, Allie. In Florida, are the courts open and available as we've read, at least in this motion? Can guys take action now if they feel like their rights in terms of custody are being infringed or they're not getting anything? Can they go file similar to this case that we've just read about?
Absolutely. There is nothing preventing anybody from filing, certainly on emergencies, depending on which county it is in Florida. Some counties are doing all of their hearings, not just emergency issues, not just urgent issues. They're hearing anything by either phone or Zoom hearings. And then other counties, they're limiting it more to the more urgent issues, but we are able to file everything. We do so electronically. We're able to have communication. The courts physically are closed, but certainly the judges and the judicial assistants and all of our offices are open. We're able to take action.
Great. Hey, Doug, there's another article that just is across the news from the Washingtonian, which talks about, and it makes a lot of sense. Now we're in shelter in place. We have close quarters between perhaps couples who already are experiencing problems, whether it be financial or communication. They may be already in the middle of their divorce. And this article talked about the opportunities for guys out there actually discovering misconduct, now having a greater chance of finding that evidence. Is that what you're seeing now and hearing? And does it really matter up in Utah?
So absolutely, we're seeing that occur. I mean, the reality of life is when you're stuck in a home with someone that's trying to hide something, man, it's so much harder to hide something when you're with that person as much as this quarantine is making happen. So absolutely, I think that's happening more. In Utah, it's sort of a gray area. There's a statute that allows for fault to be taken into consideration only in regards to determining alimony. But really, it's case by case depending upon the judge, and some judges enforce it and some don't. And so it's a tricky gray area in Utah.
Yeah. And I think it really emphasizes the need for preparation. We're going to talk about that in one of our 5 stupidest mistakes that guys make when facing divorce. Kumita down in Maryland, same question for you. If guys should be busy kind of finding some misconduct, finding evidence, just making observations. I always talk about be aware, listen. Does that matter in Maryland? Can guys use misconduct to their advantage?
Absolutely. Yes. And I have used it to my advantage in cases. As a fun fact about Maryland, it's actually adultery is still a misdemeanor on our books. It's punishable by a $10 fine. But it's super relevant in family law cases. We do have fault grounds here in Maryland. And if your case is uncontested, and that really just means if you don't have a marital settlement agreement resolving all issues out of the marriage, adultery is one of the most common grounds that we have to use because otherwise you have a 12-month separation period in Maryland. So adultery doesn't require a waiting period. So it's a big deal in the sense of the grounds that you want to file for. But you do need to have evidence to prove the adultery. But the adultery also comes into play with both alimony, like Doug said, in his jurisdiction, but not just alimony here in Maryland. And I've had to use this in cases about property. We have property factors that are almost identical to the alimony factors. And one of the factors is circumstances that led to the parties being estranged. So I have used adultery to win my clients money and property. So it is a big deal, and you definitely want to document it. Another thing is social media, just making sure you get a screenshot of any texts, whatever you can get. Make sure you document what's going on, or even if you can write a journal, keep notes.
So we'll get to a lot of that in terms of inaction and what guys should be thinking about, because I think that article is so relevant right now during COVID-19. And so let's get right to the heart of our 5 stupidest mistakes, and we'll go through that, and we'll take a small break and join 2 other panelists. But in the 5 stupidest mistakes, you may have attended one of our webinars that we have around the country where we have a room full of 100 plus guys, where we have actually talked about the 10 stupidest mistakes that guys make when facing divorce. In fact, we've written a book about the 10 stupidest mistakes. And some of the feedback we get is obviously, hey, I've made every single one of those mistakes. And I'm sure as you listen today, you're going to find yourself that you may have made one, but it's okay. You still can recover from it. It just means you need to go have that consultation with your attorney. And again, this is really meant to stir that conversation, to get you to recovery, to put you in the best position to attain the goals that you want to achieve. And so I remind you, before we get started on the 5 stupidest mistakes, is to submit your chat questions so we can get to those right after the break. We'll take those questions live. We'll do it in a lightning round, and we're going to do that in 60 seconds so that we can get through as many as possible. Again, encourage you to submit those chat questions now so we can answer your questions. So let's get right to it. Allison, in Florida, one of the first mistakes guys make when facing divorce, whether it involves COVID or not, but more importantly right now, is moving out of the house. And typically I'm always telling guys, look, don't move out of the house. But there's exceptions to that. In the evening I tell them, look, if there's domestic violence, you can leave with the kids, certainly do it. But keep in mind again, each of your circumstances will change based upon this response. But Allison, down in Florida, what do you recommend to guys, especially now, about moving out? And really, are there advantages or are there disadvantages, or both, if they choose to stay or move out?
So I think that realistically, more times than not, we see disadvantages when the father or the husband chooses to move out. I think the biggest thing that I would encourage anybody to consider when thinking about whether they should or should not move out is, what do you have to gain or lose from it? And talking to an attorney about that has experience in family law, so we can talk you through that and strategically make a decision that's best for you. Realistically, it can impact everything. It can impact your visitation rights with your children. It can impact expenses. You still have a status quo that you have to maintain of the specific expenses to the household, plus any new expenses you're incurring from wherever you choose to move. And also child support and alimony exposure comes into play. It's certainly not an impossible thing to do if you need to, like Scott mentioned. If there's domestic violence concerns or something like that, we absolutely need to talk about that, and that may be the best decision, but let's do it in a strategic manner. Realistically, what I always encourage is, what do we want to happen in the long term? We want to be fighting for in the short term. So really, we just want to do it in a way that we're best building it to your advantage in your full case.
Yeah, and I think, you mentioned household expenses, Allison. One of the things I've talked to guys in the evening about is, this is a very emotional moment, during divorce, and you make decisions without really thinking through it. And they face what I call double household expenses. Now faced with 22+ million people unemployed in the United States, you may be one of those guys, and really, or maybe your spouse, it was a dual household income and you're living paycheck to paycheck. What happens to guys? Talk a little bit about that. What do we mean by double household expenses?
Well, realistically, that means that you're paying for either rent or mortgage in two different households, electricity bills, all of the standard expenses that you have to pay. And most of the counties in Florida have a status quo order that requires you to keep on paying and contributing to the normal household bills as you previously were. So for example, if you and your spouse were a dual income household, you both shared equally in the mortgage and those other expenses, you still have to pay those. Until a court says otherwise, you are still on the hook for half of that, in addition to whatever other expenses you have to pay. And so you may find yourself in a position where you don't have the ability to pay all of that, but you are the one that voluntarily chose to move out of the house and incur these other expenses. So you could be potentially in violation of that status quo order.
Yeah, and I think that double household expense item, that mistake and overlooking it when you choose to move out because you want nothing more than just to get away, especially, in a shelter in place. You can overlook the damage it can do. This is regardless of whether you have kids or not. But Doug, when we have kids, up in Utah, when you see a guy that moves out, one of the things I think they overlook is what I call abandoning their kids. Not in the legal sense, but can you talk to guys about kind of the impact of that decision if they move out without their kids?
Of course. So what the courts are looking for in Utah is they're looking for what's happened from when you guys separated until whenever you get into court. And so the reality of the situations we're in even now is I feel like it's more important not to move out because the court could interpret that as, hey, you've abandoned your kids. Coronavirus has given parents, if there's not a current court order, this ability to deny parent time. And if they deny parent time and you're losing parent time from when you move out to whenever you get into a court case and in front of a hearing, in front of the judge, that could go very negatively on your side, and it could hurt your case substantially. And not only that, but if the other parent is denying parent time, that goes to parental alienation. And from my experience, that is one of the most difficult situations in a case. And what we're dealing with right now with COVID-19, not only it's going to lengthen the time that you're not going to be able to see your kids because you're not going to be able to get into the court as quickly as we used to. But that parental alienation is just easier for someone to do based upon what's happening. It makes the case a lot more difficult with getting children.
Yeah. When I mentioned kind of the abandonment of kids, it again, guys can take that in a legal sense. It's not. It really is what I explain is when you decide to move without your kids, especially right now, the time that you think you're going to get is probably the time that you're not going to get. And you're not going to see them as often. Mom may use COVID-19 as an excuse to not move them and transition them, to have that custodial time. And so you have no idea what's going on in that home. And you raise a good point, Doug. Parental alienation. We do these webinars or these seminars in the evenings. When I ask guys in the room full of 100 guys, how many have heard of parental alienation? And you maybe, if I'm lucky, I get one hand that goes up. So in Utah, talk to guys a little bit about parental alienation. Can it be used in court? And are judges receptive to that kind of evidence? And then maybe I can talk to you a little bit after that about examples.
Yeah, so it definitely can be used. The difficulty is always proving it, because the courts, at least from my experience, is they always trying to find a happy medium. Well, parental alienation is one of the worst things you can do to your own children. And so the courts don't like to believe it's happening. And so usually to prove it, you've got to get some kind of expert involved, which is going to increase the cost of the case. And that expert has to take time to meet with the children, meet with the parents. And it's a very difficult process. And sometimes even the experts miss it because it's something that's so hard to prove. And so it definitely can be used. But why it's so difficult is just proving it. There's very difficult situations that it's hard to prove. It's hard to know exactly what's happening in mom's house when you're not there.
Yeah, exactly. So I always say the best way to kind of defend against parental alienation or stop it is stay in the house. That's why 98% of the time we're saying don't move out. But I think it's a great transition to the mistake number 2 when facing COVID.
Can we back up to that just for a second?
Yeah.
Let's talk about the fathers, maybe somebody who's not married. You have a father like in Ohio who you don't have any custodial rights when a child is born out of wedlock until you go into the court and request them.
Yeah.
So in those situations, if you move out of the home and you weren't married, you don't have any rights. You don't even have any rights to go back to the court to say that someone else violated.
Yeah, that's a good point. We talked last week about paternity, and guys come to me and say, look, I'm being denied. What can I do? And in fact, we were all exchanging emails today about a gentleman who is not seeing their child but has no order in place. And so it's even worse because you have no idea what's happening. And that parental alienation, I've seen it 17 years later, and the relationship is nearly destroyed. It's devastating. So, I encourage you to talk to your lawyer about staying in the home. But a good transition really is failing to act, which is mistake number 2. Kumita, whether it deals custody, we'll talk about that. But more importantly, right now, with 22 million plus people unemployed, figure 11 million guys out of a job. We've got half of those, say 5 or 6 million, that have a child support order or an alimony order. They can't afford it. I don't know how they make that payment. The question becomes, should they just sit, or failing to act? Is there a problem? Is that a really big mistake to just do nothing and wait till this is over?
It's a really big problem. In my state, and I think from what I've heard in these webinars, a lot of other jurisdictions, alimony and child support really they go back to the date that you actually filed. So if you lost your job, get in contact with an attorney and try and file for a modification of child support so that the court is on notice. It's not willful. Because another thing is, if your child's mother decides to take you to court for missed arrears when you've lost your job, the court is going to look for, is it willful? So try to make good faith efforts, pay what you can, show that you're making an effort. Also in Maryland, we have something called voluntarily impoverishment, which means the court can impute an income to you if you actually are just unemployed for the fact of being for not wanting to pay child support. So you really do want to show, and if with your job search as well, jobs, making those efforts to find new work. But another thing I did want to bring up also on child support is what I've noticed from my time at Cordell and having mostly male clients is that they don't like to ask for child support when they're the primary custodian, and they're more often than not, they're entitled to a lot more than they think. Now may be the time, if you're unemployed, you may have been too proud to ask, or it was something in settlement, but now is not the time to let your children have to feel the brunt of that. So you really do need to get that child support. And you can actually file in Maryland through the Office of Child Support Enforcement as well, if you can't afford an attorney at this time.
Many guys, Kuma, it's a good point about action. That right now they're saying, well, I can't afford to file. And the point is you can't afford not to file, really based upon that retroactive child support amount, because if you do nothing, you're just accruing debt that the court, I assume in Maryland, is powerless to deal with between the time that it's the event of the decrease or loss in job to the time that you file. I assume they're still owe it, right?
Yes, you're still owed it. The court can forgive arrears. I looked on the Maryland Child Support website just to see if they had any response. They had a quick FAQ. One of the things they said was that arrears are being looked at on a case-by-case basis. They also mentioned there may be some backlog in applying, but you can still open a case online.
Yeah. Melinda, when we talk about, taking action and failing to do it as being, the number 2 mistake right now, especially with custody, up in Ohio, our courts open, we talked about Florida. Can you file a temporary motion right now, and should you just wait till this is all over and then go to get court action?
So you can still file in Ohio, and a lot of our courts, once you get filed and you still have to serve the other party, there's still that backlog or that waiting time to get into court, even under a normal circumstances. Coronavirus is dictating our lives right now, so it's delaying everything. But in some instances, if we file now, it may not be any more of a delay than what normally would have been should we have filed COVID-19. So definitely you would want to file now. So you'd want to protect any retroactivity that you would have one way or the other. And in addition, when Kumita was talking about some child support arrears, be cautious, because a lot of tax refunds are still being issued. And are these going to be intercepted when the parent is actually going to be counting on that money in order to make ends meet, whether it's to pay rent or whatever during this time of furloughs and people being laid off?
Yeah, Kumita, good point, Melinda. Kumita, though, we talk about child support modifications, and, I can't afford it. I just want to mention to guys, though, to check out and give us a call, because we rolled out a new program that really caps attorney's fees for guys on child support modifications. And I won't get into that in a lot of detail. Just encourage you to call us. We can kind of solve that question of how much will it cost you, and now we have the answer. But what's more important, was we're not really talking about, is there's guys right now that have problems in their marriage. They didn't get a chance to file. They want to file. Should they file? And, is there a reason to wait, in Maryland for guys who are thinking about divorce, or should they get in line and get filed now, and can they file?
There's no reason to wait. We can file. We have an e-filing system, and for the few counties that don't have e-filing now, they have a virtual Dropbox system. So you can file. We had some bad news the other day that now the courts are closed till June 5th. So there is a backlog, but you need to be able to file on time and show the court you made the immediate attempt. And I mean, another thing, going back to what we had said, we were talking about earlier with the fault grounds, because we have that 12-month separation period. In Maryland, if you have adultery, so it's important to file now. It's important to file what you can now, just so that the court can see. I mean, it may take a very long time to get to court. We don't know, because everything's kind of up in the air, but it is important. And the judges will always see the docket. It's going to be part of your file. They will see when you filed. They will look at the timing.
Yeah, I think it's a huge point. Most judges, that's why we listed it as a big mistake. They'd say, why did you sit around and do nothing? They expect guys to kind of defend their rights and pursue their rights. And so I think that's huge. Before we move on to the next mistake, I want to continue to encourage you to submit your questions online live so we can address those after the break. We'll get to the lightning round, where we'll have our panelists spend no more than 60 seconds in a rapid fashion trying to get you some quick tips, some quick talking points as we move along. So let's keep on going. Doug, up back into Utah, one of the third mistake guys make when facing divorce or in the middle of a divorce and COVID is really inaction. And I talk about that. Let's just say the guys that have their case pending, is there something that guys should be doing, or should they just wait? Kumita said, hey, courts are closed till June 6th. Should they just do nothing while the divorce is pending?
Absolutely not. So one of the worst things that you can do in your divorce is nothing. And we're lucky in Utah that we are still having a lot of hearings. They are via Zoom or telephonic. But even if you're in a state that they're only conducting emergency hearings, you should still be moving the case forward. I tell clients when they retain that we really have a goal of pushing your case from the beginning to the end as quickly as possible. And yes, COVID has slowed things down to some extent in the court, but there's so much to do. going to court is only the final step of a case, right? You have discovery, you have preparation, you have motions. So there's still so much that you can do. Specifically, what I would suggest is especially if your circumstances have changed, if you've lost a job, if your income has changed at all, you need to update that. You need to work with your attorney to ensure that's up to date, because that could come into play with all of this. Also, one thing that I've encouraged my team to do is depositions. Depositions are one of the most helpful things in a divorce, and I don't think they're utilized for as well as they should be. And so that's something that you can still do via Zoom or some other manner. In Utah, they've actually got rules that allow us to do all of that via video, so we don't have to be close to anyone. And so that's very essential. And then trial prep, man, we can still call, talk to witnesses, prepare exhibits. There's a lot of that kind of preparation type work that needs to be done, that doesn't matter what's happening with the courts, you can still do that now. And on top of that, I know a lot of these cases settle before ever going to court. We're still conducting mediations. We're still sending out settlement offers. In fact, I had my first mediation via Zoom last week. It went well. We settled it well for the client. So there's still so much that you can do in these kind of situations. And even if it's a case that you believe has to go to court, there are even options for that. In Utah, we're allowed to, if there's an agreement between the parties, we can do a binding arbitration, which is similar to a trial, but it's a lot easier to do via Zoom and not in a courtroom. And so there's so many options. And if the attorney is just sitting and waiting because of all this, or if you're sitting and waiting because of all this, that is not a smart strategy, because you really need to prepare now so that you can move your case forward as soon as possible. And from my experiences, is we have much better results when we do all that prep work and we move the case forward. And I don't think COVID-19 changes any of that.
No, I agree. I was just talking today during my daily podcast about with one of our attorneys in Georgia who actually settled a case. And they filed it shortly before COVID, settled it during COVID, and now they're actually judge signed off on it. And so I think it's very important to not overlook that we've got these distractions are gone, with the busyness of work and perhaps, the court hearings and settlement conferences, that you can really focus on your case. You can get through your discovery, talk to your attorney, talk to the other side, engage in informal mediation, and perhaps settle your case while COVID's pending. So again, encourage you to submit your chat questions. We're going to be addressing those shortly. We'll go to a break real quickly while we gather two more panelists. And Allison and Kumina, thanks for joining us. And we'll be right back after these messages.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
Welcome back, and joining us now for the second half of our live webinar is Sanders Patton out in California. Welcome, Sanders.
Good afternoon, Scott. I'm an attorney that's been practicing in California for approximately 11 years. I have a dual background in both criminal defense and in family law.
Welcome, Sanders. And joining us again from the state of Texas is a Cordell Cordell partner, Kelly Burris. Welcome back, Kelly.
Thank you for having me again. I am licensed in Texas and Oklahoma. I've been with the firm for almost 13 years. I am also board certified in family law in the state of Texas, one of 860 out of about 100,000 attorneys. So I'm happy to be here.
Thanks, Kelly. So moving along, just keep in mind, again, submit your chat questions so we can get to those here shortly in our lightning round. We want to be able to get your answers as best as we can. So make sure to submit those via chat and we'll try to get to those. So moving along to our fourth mistake that men face when considering divorce really is failing to participate in children's lives during COVID-19. We're in shelter in place. Things are abnormal. This is maybe a new normal. Sanders, out in California first, before we get into that mistake, what's the status of the courts in California? Can things be filed, knowing that perhaps the physical building is closed, but, can guys take action in California right now if they need to?
Yes, you can. There's different courthouses that are taking different stances. Everything is fairly closed at this point. Courthouses are open for emergency bases. They're also open for certain special hearings like domestic violence restraining orders, other non-family related things that are emergency based like juvenile issues. But for the most part, you can get into court under limited circumstances. That's something you'd want to talk to your attorney about. Obviously, California is doing things a little bit differently than some other jurisdictions might be doing it. The other thing that we're seeing in California is that the courthouses are taking things in segments. They haven't made any very long-term blanket closures. Right now, actually the 16th today is a day when they are going to revisit and dole out some new guidelines as to, what the upcoming hearings are going to be like, what the court openings and closures are going to look like for the next couple weeks. It's a difficult process for everyone, trying to make sure that we are all staying safe, but that we are not preventing individuals from getting into court when they need to, when they have emergency issues. And that brings me to the issue of an emergency. What constitutes an emergency is up in the air. It's case by case basis. That's something that you definitely want to talk to your attorney about, see what your local jurisdiction is doing in terms of qualifying what constitutes an emergency. Are you going to be able to get into court in front of a judge with your issue or not? Is it something that you're just going to have to file and preserve for a later date and time when the court reopens?
So, Sanders, in one of the mistakes, number 4, the stupidest mistakes guys make is really, as I said, failing to participate in their kids' lives. Because right now, in a shelter in place, guys right now need to know someone's watching. And it's likely your spouse. And someone's taking notes, someone's recording everything you do and everything you don't do. And maybe talk to guys and give them some ideas of what they should be doing right now with regards to their kids when they're living with their spouse and maybe right about ready to file for divorce in the middle of it. What should guys be doing with their kids to stay as involved as possible?
There's a lot of things that you can be doing with your kids. Obviously, with kids being home now, with schools being closed, you have a great opportunity to spend a lot of time with your kids doing things that you don't often get to do. They go to school. If you have school-aged kids during the day, you don't get that time with them. You don't get to participate in their lives. And we all understand that there are things that you have to do during the day. Maybe you have to work, maybe you're an essential worker, but taking the time when you have that time with your kids to help them with their distance learning if they're in school. I have a daughter who is a preschooler. She's about to go into kindergarten. There are still things that we can do for kids that don't necessarily have a lesson plan that's laid out to help them with this time where they're not learning, where they're not progressing themselves in their education. You can communicate with their teachers, make sure that you know what it is that they need to be doing. You're going to have kids here for the next couple months who are going to go into a grade level without the benefit of the second semester, essentially, of their past school year. So you want to make sure that you're putting them in the best position possible to get to that next stage in their lives. Communicating with teachers is essential for that, to make sure that you're doing what they need to do, and help them with their homework. Obviously kids need different levels of assistance with their homework. The younger they are, the more hands-on you might need to be. The older they are, encourage them to self-work. Put yourself in a position, and this is my advice to everyone essentially at this point, is put yourself in a position to document your efforts, to show that you are doing everything you possibly can do and taking your kids' best interests into heart. That's the standard that California and most states are using in terms of looking at child custody. What is in the best interest of the children? And right now, helping them during this scary time, during this time where things are completely different, is vital. So do everything you can to assist them, document those efforts. If you want to post it on social media, post it on social media. Take pictures, retain that information so that you can use that at a later time if it becomes an issue. Don't do nothing. Don't do the minimum. Don't just, plop them at a table and say, go figure it out for yourselves. Because as you said, Scott, you don't want to give anyone that negative ammunition to use. Yeah. You want to put yourself in the best position possible.
I mean, I think, all the things you point out and all the things we say about, failing to participate seems so obvious. Of course I would do it. But the point is when you don't do it, it matters most, because your wife or your spouse is going to use it against you. And so you need to be over involved. And that's the recommendation we give substantially. And you make a really good point, and that is document. Write everything down. We encourage guys out there to make a journal every day. Keep it in a safe place so your spouse can't get it. Send it to your attorney every day. Make sure that they keep that. So thanks, Sanders. So moving on to the fifth mistake guys make when facing divorce during COVID. And this one's a tough one, because we know that right now, especially in close quarters, guys are facing this issue, and it happens quite often, and that is allowing confrontations to occur and or escalate. We talk a lot about in the evening about making sure that you don't get into that situation with guys. Kelly down in Texas, if guys get in a situation where they're arguing with their spouse, and what can happen, what can their spouse do that could be devastating to guys during this period?
Well, arguments can easily turn into something more. And even if there's not physical violence, that can lead to protective orders, that can lead to temporary restraining orders and injunctions requiring the husband or the dad to move out of the house. I have, matter of fact, a couple of cases right now, and throughout my career, I've had multiple cases where the wife or the mom was the aggressor, and my client ended up getting arrested for family violence and ended up getting prosecuted for that, even though the evidence eventually showed that he was defending himself. And that puts you in a very defensive position with respect to any kind of custody or divorce case, even if it's not kids. Property issues, spousal support. It affects absolutely everything when there's some kind of finding of family violence. And it's very easy. I think it's harder for guys to get a finding against a wife or a mom than it is vice versa. So I think you have to be very, very cautious to be sure that those situations are getting diffused. The one thing that I always kind of tell clients, we talk about one of our mistakes that men make are moving out of the house. I think the only thing that's worse probably than that is ending up with an arrest or a finding of family violence, because that just puts you on such a defensive position. And that's not the position that you want to be in. You want to be in an offensive position. You don't want to spend so much of your time trying to prove that this allegation is not true, that you fail to be able to have time to prove what a great dad and what a great husband that you've been. So it's really important to try to diffuse those situations as much as possible. Be careful getting the police involved. It's kind of one of those really hard decisions when maybe the wife is the aggressor and, you as a husband or a dad are thinking about calling the police, but you got to be careful, because I've had multiple cases where, my client called the police and they ended up arresting him or making him leave. So, I think making sure you're documenting those situations. I always tell clients, if it starts getting really heated, pull out your phone and start videotaping everything. Yeah. So at least you can show that, it wasn't what you can show the police when they get there exactly what happened, and you have evidence of that.
I think the danger, with this, it's why it's such a mistake, is even the smallest argument that escalates, whatever they say may not be the absolute truth, but the consequences are you're out of the house, especially during this pandemic. So now it triggers every mistake that we just talked about. Double household expenses. You're not involved in your kids' lives. You're not getting the custody that you want. And now you really have a choice. You got to go file. So inactivity and doing nothing is not an option. And so every mistake is triggered by this last mistake here. And so it's really damaging. Melinda, in terms of these orders of protection, how can they be used at trial if, the wife or the mom is successful in getting something and getting dad out? How can they use it? Can they use it in Ohio? And, is there a stigma with it? And, how damaging is it to guys?
Yes, there is a stigma with it, and it's very damaging. Even if you weren't the aggressor, as Kelly was indicating, if you're always the one that's going to be looked at if you're the male that was the aggressor, even if you weren't. So that's always a hurdle that we always have to overcome when we are dealing with fathers and husbands, is that stigma that the courts do place. And one of the factors for custody and parenting time is there domestic violence in the home? And then in addition, the other factor to look at, is this happening in front of the children? So in Ohio, we have a lot of guardian ad litems who are appointed to do an investigation and make a recommendation to the court about what's in the children's best interest. So they will also get records for their investigation to look at to determine what is in that child's best interest. So that stigma is going to carry with you, and it also could impact your job. The financial impact is great because there could be double expenses at that point. And, what about carrying concealed weapons? There's those issues that come along with any type of civil protection order or protection from abuse orders, as it's called in some states.
Doug, I'm going to really toss it to you just quickly. In Utah, typically, where I'm licensed in Missouri, is you get an order of protection and you're really almost guaranteed to have a hearing within, say, 2 weeks. Now that the courts are closed and they're only hearing emergency motions, the question really becomes, how does it work in Utah? Maybe they're even extending these temporary orders of protection, which really amplifies, the problem for guys in that they're out of the house. They may be even ordered to pay some support that they can't afford. They're not getting the custody that they want. What's happening in Utah? What are you hearing right now with orders of protection?
So we're really lucky in Utah that although the courts are not allowing people to come to the court, they're doing all of these via telephonic hearings or Zoom. And so we are still having those hearings in Utah, and they haven't been delayed at all. So I know that's not the case across the country, but here in Utah, we're still able to get into court very quickly and contest them and deal with them just as we did before COVID.
So now we're getting,
one other issue that we're having is when we do have these temporary protection orders in place, and we're looking at, temporary parenting time, whether it's the father or the mother that's been displaced from the home, is where can this parent have parenting time? A lot of our supervisors or the facilities that would supervise this kind of parenting time are also closed down because of the COVID-19. So these parents are losing parenting time that they normally would get even if it were supervised.
Yeah. Not even to mention, it's a great point because a lot of hotels are closed. So where are guys going? They may not have any friends or family. It just, the idea of allowing an argument to escalate, just you walk away. Go to a room, shut the door, lock it. As you suggested earlier, record it, avoid it, because to me, it is the single most over-abused portion of the law across the country, just because the standard is so low. Because judges don't want to be on the television. They don't want to be that one judge that doesn't give an order of protection and something terrible happens. So the likelihood of getting it is pretty good, regardless of the truth of the matter. And then they just figure, well, they'll come back into court in a couple weeks and they'll take care of it. So thanks. Let's get and turn to, or again, continue to submit your questions via chat, and we'll try to get to those and make sure we can answer some of your questions. And again, tune into the podcast as we go. We'll answer some of the questions you submit via email. And so let's look at some of the chat questions that have been submitted right now. Simon in Massachusetts asks, one of my kids is being tested for COVID-19. His doctor recommends he and the family quarantine until the results. My ex and I have joint custody, and the kids live with their mother. She's asserting that they can't have any of the custody. The question becomes really, Doug, what do they do?
So in Utah, we've actually had an order put out by the court to deal with these type of situations. So in Utah, it's pretty nice because we just pull up the order and we follow it. And so what it says in Utah is that if dad had any contact with the children in the last 14 days, he should actually be quarantined and self-isolate as well, which means that he is part of that group that should be isolating, and the kids are as well, so that the kids can still go back and forth. Now, the problem comes is when he hasn't had any contact in the last 14 days, which hopefully isn't the case here. But if he hasn't, then he is excluded from getting any parent time in Utah until that child is not positive and a certain time frame passes, so that we know that everyone's going to be safe. Yeah. But sadly, that's how it is in Utah.
Great. Well, Austin also submitted a question. Austin's question is that my ex has had her boyfriend visit from a different state that is also under a stay-at-home order, just like the state we live in. Our daughter is a high risk. Could this be used to suspend time sharing during the pandemic or some visitation? Sanders, what do you say?
Well, the general advice that I have seen here is that, sorry, my video got stopped. There we go. The general advice that I've seen on these before, and the general advice I would echo here, is that you have to follow your current orders. Obviously, this is a trying time. There are certain circumstances that have come up that we've never dealt with before. Communicate your concerns. Make sure that you're following best recommended practices in terms of staying safe, keeping your children who might be more susceptible safe. Be on the same page, because again, when you come back to the court, you want to make sure that you have done everything you can to make yourself look like you followed the rules. Yeah. But you cannot unilaterally just change your custody orders. That would, I think, be in the negative category once things got going back up here.
Agreed. So Dalton down in Texas, Kelly, this is for you. Dalton's in a paternity battle trying to get custody. Mom is denying him the child because of COVID-19. If it lasts for a few months, Dalton's concerned that she could use this as an excuse that he didn't bond with the child. What do you say?
Well, again, it depends on the jurisdiction, but most of the courts are hearing emergency issues if he has a current order. It sounds to me that the situation might be that paternity has not yet been established, so there may not be a current court order in place. I think documenting his attempts to try to get some possession and access and time with the child, and then that way, if he doesn't have a current order and he's made attempts and he's got text messages, emails showing that he's very much trying to bond and have time with the child, even if he can't get into court to get that possession ordered, is probably going to end up backfiring on her. Because even maybe he hasn't had as much time, but then he can show that it's her that's failing to co-parent and not him.
Great. Melinda, Scout has a question and says, can you lose scheduled visits during a quarantine? Essentially, Scout's being denied visits right now simply because of COVID-19. Are there repercussions just because of that up in Ohio?
So no one should be denying visitation just because of COVID-19 if you're not self-isolating or put under that self-isolating quarantine order because you've been symptomatic or you've been exposed. So he should still continue to have his parenting time with the child. If he's not, then he definitely needs to file with the court to preserve his action. And then also, if there's not a pending action in the court and you're filing something, it usually means that the other party is going to get served and they will hire an attorney. Hopefully the attorneys can get together, talk with both clients, make sure that they understand what these orders and directives are that we must follow and that we should be following for the best interest of the children during this time.
Yeah. So Sean's got a question from Georgia. I'm going to go out to Doug. And keep in mind, as you're submitting your questions via chat, again, we don't want to be giving you advice. This is just kind of off the cuff, random, lightning round, giving you some talking points. We encourage you to contact an attorney immediately with all of your concerns to make sure you enforce your rights. Obviously, we're available if you want at 866-DADS-LAW or CordellCordell.com. So let's go back out here. Sean has a question about, my wife has a boyfriend that goes in and out of her home. I have custody of the children, and she has visitation every other week, Wednesday through Monday. Sean's denied her the kids, and she's brought the police. The police will not take the children from me. What ramifications will there be when the courts reopen? And let me throw that to Doug real quickly.
All right. So if I understand it right, what's happening is he's denying the children. Was that what I heard right, Scott?
He's denying mom, presumably based upon COVID-19. The police, as usual, don't want to get involved. And so he really is concerned, what are the ramifications with the steps that he's taking in denying custody?
Right. So sadly, if he was my client in Utah, I would tell him you shouldn't be denying. Now, I get the fear and the frustration with the situation that mom might be doing things that are putting his own child at more risk. But in Utah, the commissioners and judges have made it crystal clear that what the ramification is going to be is mom has a case for contempt, and she can bring that. And after all this clears and they can have a court date, he will likely be held in contempt, meaning he's probably going to have to pay for his ex's attorney's fees, and there's likely going to be some kind of makeup parents' time. And so in Utah, if he was our client, I'd advise him you probably do not want to do that unless you're willing to accept those consequences at the end of all of this.
Yeah, and I think, again, I would encourage...
What we should be doing really during this time is we really should be communicating with the other parent to make sure that what is best for the child is being handled. So the concerns, is this gentleman, is he expressing his concerns to mom during this time as to here's why I don't want to give you the children, and then maybe they can come up with a reasonable solution themselves until we can get into the court to determine what is best if the parents, who should be able to determine what's in the best interest of their child, not the court, can't figure it out on their own. So why aren't we communicating? So we should be communicating first to make sure that we're trying to come up with a game plan that we can continue to co-parent and hopefully alleviating some of these frustrations and concerns that we have why one parent's withholding the child. And maybe it can be alleviated by saying, okay, well, after he's gone for 2 days, if you're not symptomatic, then I'll let you have the children. And then he's not coming back for a week. So you can have the children for these 4 days versus the same schedule that they were normally following. I mean, because everything's different right now anyways, with most of the children being out of school.
I would like to interject one other thing, and this might apply to some of these questions where there's concerns. Many of the courts, at least in Texas, are open again for emergencies. So before you go deny possession, if you think that your child's at risk, look into filing some kind of ex parte or emergency order. You might be able to get the judge to suspend visitation or possession in the interim until the court can determine if there's a substantial risk.
And along those lines, Kelly, I'm going to have you answer this one from James. James had a divorce that was finalized last year. His ex has filed a modification, and obviously during this pandemic, it's been postponed. But some of his ex's coworkers have tested positive, and from the question, I take it that she's really taken no action to quarantine herself. And James believes that keeping the kids would be the best situation for them to ensure that they limit their exposure or their chances. Can he keep them until she shows no symptoms or probably finishes that 14-day quarantine period?
Well, again, it depends on the state. So some states have very specific rules regarding this that, hey, if you're exposed and you should be quarantining and the child hasn't been with her for 14 days and is not part of that quarantine, then potentially. Without that, though, I wouldn't risk an enforcement issue, and I would attempt to, go see an attorney and attempt to maybe get some kind of immediate emergency order relating to the risk that the child might be under given the possession. But I wouldn't deny possession without a legal basis to do so.
I think it's a proceed with caution. Don't do what you don't want done to you, and consult with a lawyer, communicate as has been suggested. We have about 2 more minutes of questions. Sanders, Michael has been divorced for 4 years. His ex is currently unemployed for the last 8 months. He really wants to file a modification for custody of his kids. He doesn't pay any child support or alimony right now. What is the standard in California for seeking a modification to get custody?
The standard for seeking a modification for custody depends on whether you have a final judgment or whether there still are temporary orders in place. Either way, there is required to be some kind of a change in circumstances. And so you would want to talk to your attorney about what it is that is the change in circumstances that would warrant you going to need to seek a modification. And as we've talked about, at this point, courts are closed. Document those things, get your issues filed and preserved so that when the courts open, you're in the best and soonest position possible to go seek that modification.
Melinda, this comes from Ohio, so I'm just going to toss it right back to you. David has a question, although I'm a little bit confused, but he says, are we saying spousal support goes back to the date of filing for divorce or responding to the complaint, or does it go back to the date of filing for modification of the temporary order? And so I guess retroactivity is the question.
Yeah, I think that it's really a two-part question. So if there was a request for temporary spousal support, it can go back to the date of filing. So depending on the court, some courts will issue status quo orders, like keep things status quo, and then adjust spousal support if it's needed. If there's, for the mother, let's just say staying in the home and the father left, is that spousal support going to be in the form of payment of the mortgage or something of that nature? As far as a final order of spousal support, it can also, if there was no temporary support, the court can adjust that date back to the date of filing. I don't see that. Usually if there's going to be a spousal support issue, it usually is a temporary order request, and that's either denied or granted. And then a final order is a different order compared to what the temporary support order was.
Great. Thanks, Melinda. Well, that does it for our live webinar. If we didn't get to your question and your chat question submitted, tune into my podcast, my daily podcast, where each week I will devote an entire podcast just to answering the questions that you submitted today so that we can try to get you some answers. But obviously with everyone submitted, go ahead and get that consultation scheduled. You can call us at 866-DADS-LAW or go online at CordellCordell.com. Again, tune into our daily podcast. Tune in next week where we'll also address some of the questions again live during our national webinar. You can also tune into our UK webinar, which we will be taking care of some of the questions for the guys in London as well. Again, thanks to our panelists for joining us. Thank you for joining us today. Each day that passes, we're one day closer to opening up the country. Thanks to Lexicon, and until next time.